Hi, I'm Adam Samaha, and along with Ryan Goodman and my co-panelists, we decided to organize this discussion so we could offer some of our initial thinking on the emerging constitutional issues that are stirring. And we've got several experts from several different fields, and we're each going to talk for a bit and try to preserve some time for questions at the end. So we're going to be covering a wide variety of topics, and the idea is to initiate discussion and analysis about these topics. And of course, we won't be able to come to closure. So we'll start first with Ryan Goodman. We've ditched the idea of a moderator. That just seemed kind of hierarchical and unnecessary. So we're going to introduce ourselves. I'll turn it over to Ryan to introduce himself and to talk about the use of force abroad.
So I'm going to just speak briefly, I think we each are, and then so we'll have enough time for conversation and discussion. So I'm Ryan Goodman, I'm a professor here, and one of my main areas is use of force rules. So when can one state use force against another state, and law of armed conflict rules, what are the rules that apply during that use of force or hostilities. And I want to try to raise certain kinds of constitutional law questions that I think might come up during the Trump administration. So I thought what I would highlight is basically a kind of a challenge between what currently exists, the status quo of a congressional authorization for the executive branch to use force against al-Qaeda and its associated forces versus the president's Article II powers to use force without congressional authority on his own terms. And I think the danger that lurks is that a Trump administration might begin to use force against new enemies, new groups that it identifies as national security threats to the United States, or the same groups in new countries, so opening up new fronts without there being sufficient democratic dialogue or the nation's other political representatives, the Congress, involved in that kind of a question. But what the strange place that I find myself is that I think of the status quo as unacceptable, which is a authorization to use force that doesn't easily apply to ISIL and these other groups, versus changes that could be made to the status quo that would be even more unacceptable. And so what I mean by that is that the Obama White House has been operating now for quite some time under the authorization that Congress passed in September of 2001 to deal with 9/11, and has applied that to the fight against the Islamic State. And that is legally dubious. So before I served in the government, I'd actually written about how much of a stretch it is to apply the authorization from September 2001 to an organization, ISIL, that didn't exist on September 1st. It had then come into existence with al-Qaeda, but then split from al-Qaeda and is currently a mortal combat of al-Qaeda. The two groups fight each other inside Syria, for example. So to think of them as part of the same battle is legally dubious. To think that that authorization from September 2001 applies to 2017, and where do you go from there? If it applies to that kind of a group, the so-called successor theory, that they carry the mantle of Osama bin Laden, then other groups could also pop up in the future. Now, the strongest proponent of the idea that the status quo is unacceptable because the president is acting unconstitutionally happens to be Tim Kaine on the Hill. So Tim Kaine has come the closest to arguing that the president's current use, President Obama's use of force against ISIL, is not congressionally authorized, and therefore it requires Congress to pass an ISIL-specific authorization of use of military force. One of the things I found most curious is after the election, Senator Kaine, on his first speech that he gave in the Senate, was on this issue. So he actually is still on it, knowing that the next administration will be a Trump administration. And the hearings of some of the nominees raised the question of, do you want, as the next administration, to have Congress pass an authorization for the use of military force? So the status quo might be unacceptable, but the changes that Congress would make, I think, could be more unacceptable, in the sense that it used to be thought that we wanted Congress to pass an authorization to constrain the executive branch under the Obama administration and the potential Hillary Clinton administration. But now you have to start rethinking, well, what would be the way to repair this constitutional gap? Because one of the most important aspects of the authorization for use of military force is the idea that it would be ISIL-specific. Tim Kaine has drafted authorization legislation that would be ISIL-specific. Most of them were. But I think everything's up for grabs over the next 4 years, especially after the next midterm elections when there are probably going to be more Republican senators. And I don't think Mike Flynn is going to ask for an ISIL-specific authorization. We'll be much more open-ended against terrorist organizations. Secondly, the current authorization, to try to stretch it to ISIL is one way of stretching the rubber band. To try to stretch it to ISIL's associated forces, so those groups that then align with ISIL, is maybe a stretch too far if you're dealing with the 2001 authorization. But if you were dealing with the 2017 authorization, that wouldn't be as much of a stretch. So the idea is that if you got that kind of congressional authorization, for policy reasons that might end up into more of a slippery slope of daisy chaining, like ISIL and then its associated groups and the associated groups of the associated groups of ISIL. Lastly, the 2001 authorization has been read by the Supreme Court to incorporate international legal constraints. So my main area of international law, targeting rules and the like, detention rules are read in to what Congress intended in 2001 to constrain the executive. Some of the drafts that have been proposed on the Hill in the last year and a half don't have that constraint. I highly doubt that we can count on that constraint being in the 2017 AUMF. And there's been other discussion by other groups about having that authorization. I worry about those kinds of risks. The last point I thought I'd make on this particular issue is detention. So the one area that I think about a lot is Gitmo. If Gitmo is open for service again, and the Trump administration even takes one individual in custody and takes them onto Guantanamo just as a symbolic move to demonstrate that it's still open for business, that actually might raise this as a constitutional question before the courts. So I think a habeas petition by that individual as a member of ISIL is going to raise the AUMF question of whether or not the 2000 AUMF can apply to ISIL as a group. And in some ways, that might even be kind of the strange upside of Guantanamo. If you were to choose where those individuals are detained for constitutional protections, rule of law values, you might actually prefer that they end up on Guantanamo than that they end up in something the equivalent of the Bagram Air Force Base, which federal courts have said there is no jurisdiction over that, or in the hands of non-state actors or other foreign partners, so outside of U.S. custody, and there'd be no review of that. So there's a strange quality of where these individuals end up without the AUMF. That actually might be a reason that there would be pressure on the Congress to decrease the legal risks to the executive branch to pass an AUMF at the same time that there's sentiment on the Hill to keep Guantanamo open. I think those are some of the main issues or challenges and complexities that I'm thinking about when I think about some of the constitutional questions, use of force, and detention.
That was fantastic and concise. All right, so I'm going to talk a little bit about speech and religion and, if compelled, the Foreign Emoluments Clause, but that's for later on. So on speech and religion, let me speak first broadly. So most or all of the issues that I will reference can be addressed using old constitutional logic, orthodox or conventional legal reasoning, of which constitutional legal reasoning is a part. They can be addressed that way, maybe all of them. So Muslim registries and flag burning, for example, those stand out. Or the ability of government to try to restrain leaks and what happens when information leaks afterward. These are all familiar issues on which conventional, or what I'll call old constitutional logic, does not break down. But conventional logic, legal reasoning, including constitutional analysis, can break down, and it can break down for a number of reasons. So I want to highlight two types of breakdown. So one is that the old logic just doesn't seem to work. It seems to fail in the sense that it doesn't seem to apply. You don't seem able to process an issue that seems new. And when that happens, then the people who are actually engaged in conventional legal reason, in the old legal logic, there's often an internal pressure then, a felt need for something new in order to process these problems. Now, that doesn't mean that constitutional law will necessarily govern. It might be the best option to leave constitutional law out of it. But that's one kind of breakdown. A second type of breakdown is when the old logic is able to give results. Nobody really denies that. But the logic and the results, maybe both, are under attack. So they're under fundamental challenge. That often comes from outside the legal system, per se, but it can come from within as well. So when that happens, that kind of type 2 breakdown, that I think is often an opportunity, or at least optimistically it's an opportunity, to explain why the old logic and the old results should be preserved. That should be an opportunity. And I don't think it will be adequate under these conditions. It won't be adequate to say, well, it's old, or very, very old, or unbelievably old, because the challenge is to the logic and the results themselves. Okay, so to try to illustrate that larger framework and speak just a little bit about speech and religion, let's talk first about Muslim registries. Now, I read a report that Nikki Haley, during her confirmation hearings today, repudiated this idea of having people in the United States who admit to being Muslim be registered with the federal government. So this might have been just a not very well thought out component of the early presidential campaign, and maybe it's not really a serious proposal. Well, let's just think about that for a moment. Under the old logic, this is flatly unconstitutional. I don't think it's really a close question. As long as there's some sort of hassle, and not even a penalty, but just a hassle to register based on religious belief, that's just unconstitutional. Now, there isn't terrific originalist history to support that proposition, but over a long period of time, building up lessons we felt have been learned, that's just unconstitutional to single out religious belief. Now, if somehow the singling out is religiously motivated conduct, then conventionally speaking, we apply strict scrutiny, and the government better have a very persuasive reason for singling out religiously motivated conduct as such, and it just seems impossible under orthodox old analysis that position could be sustained. So that's an old kind of logic, and it makes you wonder why anyone would propose it if they thought about it very much. And one possibility is, of course, that it's a kind of stunt or a political gambit and not really meant to be a serious proposal. So think just a minute, leaving aside legal logic, just thinking about policy and pragmatics and maybe evidence. So what would happen if you asked Muslims to register? Well, religion happens to be opaque. It's something that people can express, but they can also often keep hidden. And so what the registry would do, I take it, would punish the conscientious. So it would punish those who are willing to be honest. And those who are willing to hide, I guess, would escape, unless you have some sort of supplemental program. So you would disadvantage the conscientious. And then there were a proposed form of protest by non-Muslims who said, we will register if you set up a registry. That creates real problems for administration, and that's a bold and clever move. So then it makes you think that there or ought to be alternatives that are a little more serious. And these other alternatives, it turns out, under the old logic, I think are not much of a constitutional problem. Take one pretty obvious one, surveillance, okay? Surveillance, just surveillance and not letting anybody know about it. Now, if you do that, then there are pretty obvious and established standing problems to getting into court if that's what you want to do, to object. And moreover, a secretive surveillance program is likely to be fairly effective. Now, you can't claim political credit if you do it that way, but secretly targeting people based on felt risk within an administration seems like a much more practical alternative, and one that the old logic, actually, of constitutional law doesn't provide much grounding for complaint, at least not effectual complaint. Now, let me speak for just a few minutes then about speech, and I'll talk about flag burning first, because that's one of these old issues. It's so old. It's so 1980s, this issue. That's I think much of what we will look forward to in the next administration is a return to the 1980s, which I remember all too well. So let's think about that, flag burning. Okay, so old logic, this is easy. You can even cite cases that singling out flag burning, targeting flag burning, and punishing it because of the offensiveness of the message is just flatly unconstitutional. You can cite cases for this. And I've seen news articles citing cases for that. Now, I don't think that people who want flag burning to be punished don't understand that the Supreme Court has made a ruling. They either want a constitutional amendment or they want to discuss and talk about the issue or promote it, regardless of what some judge has said. And I think that pushes us toward a less orthodox, maybe less conventional form of reason that's maybe not constitutional reason at all, and that's to think about why, if at all, flag burning should be protected under the Constitution. So one way of thinking about the problem is, well, this is a matter of self-expression, and when the government singles out messages based on those messages, we should be highly skeptical that government officials, regulators are going to get this right. And no matter what, it's going to suppress some people's ability to express themselves. But if we open up the argument beyond conventional legal reason and think about flag burning as a practice just for a moment, I don't really have terrific evidence, but has flag burning ever actually accomplished anything other than, I guess, two things. One is demonstrating the intensity of someone's feelings. It definitely does that. And I think it indicates that the person cares not for other people's feelings, or at least a certain class of people's feelings. Now, I'm not sure how highly we want to value that sort of conduct. In fact, for many of you out there in the audience, you might think the combination of expressing yourself in very strong form and indicating you care not about other people's feelings might remind you of somebody. Okay, so think about that. The other interesting feature of flag burning is that it's very effective when it's under assault and probably is more potent if made illegal. So there can actually be a real practical function for protest when the protest is itself unlawful and the person is willing to take the legal consequences in order to show the intensity of their belief and also to confront standard operating procedure. Okay, I just have a little bit more, I have a lot more I want to say, but a little bit more that I will say to leave some time for discussion. Let me talk then about more novel issues in which orthodox legal reason might break down in maybe both ways. So think about these issues that I see rising. Number one, the president calling people names, or more particularly, calling organizations names. CNN, fake news. New York Times, failing. Now, I think under the old logic, this is really not much of a problem unless there's some realistic threat of formal legal action against these entities. Moreover, those statements can be leveraged into increased audience shares. So noting that the president has singled you out and said you're failing can actually boost your readership in a demonstrable way. And having that kind of confrontation with the president of the United States can be useful. So it can actually be to the advantage of the targets. That's at least possible. So maybe the organizations should just lump it, as they say. But there is another effect of speech like this. It seems to contribute to the balkanization of media sources and where people have an option to decide what kind of reality that they live in without checking data, evidence, or the sensibilities of other people. That's not something, that kind of issue is not something that old style legal reason or constitutional reason can handle very well, at least not yet. I'll note two other emerging issues that may or may not be constitutional in our near future. The president withholding information, not just on government operations, but on the operations of the Trump Organization and the trust system that the president has said that he will set up. Now, he's made promises about how this organization will operate, and ordinarily, there's really no good First Amendment claim, no good constitutional claim to the disclosure of government information, let alone information about nominally private organizations. But when the president makes a promise in order to try to defend against problems of conflicts of interest, when that promise is made, I wonder if this will then be converted into a constitutional debate or a discussion of constitutional dimension. And then finally, I'll just flag one more issue, and that is the president suing people. I found zero historical examples of the president suing somebody else. The president apparently does have a private capacity, at least the courts thought so in the Clinton against Jones litigation. So the president probably does have a personal capacity and can sue. So that's a hurdle that I think he could overcome. Whether the president has a cause of action is a more interesting question. Do note, though, that some untold number of people have signed non-disclosure agreements with Donald Trump and the Trump Organization, promising not to disclose confidential information. And under at least some of these agreements, confidential information is more or less defined as what Donald Trump would prefer not to be discussed, or what the Trump Organization prefers not to be discussed. So if the president himself, or more likely the Trump Organization, sues to enforce these non-disclosure agreements against people who now want to claim misconduct on behalf of the now president of the United States, how do you analyze that as a constitutional question? Seems to me the resources of old constitutional thinking probably run out. And that, I think, is where our job begins. And when I say our, I mean me and you out there too. Okay, thanks.
So when Adam asked me to join the panel to discuss the effect of a Trump presidency on criminal justice policy, I have to admit that I hesitated, largely because his request actually forced me to face the reality that this was not just a bad nightmare on 11/9, but actually was a reality. So even if I refuse to watch the inauguration on Friday, it's going to happen. And even if I refuse to acknowledge Trump's toxic tweets, they will continue. And even if I refuse to believe that someone so divisive will actually be our president, he will on Friday. So that means that I and the rest of us have to acknowledge the disturbing reality that President Trump will be making decisions that will affect the lives of people whom he has no interest in understanding. And so what I'm going to do is spend a little bit of time, since I spent a little time preparing, talking about some of the things that I've learned as I've tried to pull together a coherent set of policies, perhaps, from his tweets, campaign rhetoric, and cabinet choices. The themes that emerge when you look at all of that are troubling to say the least, and suggest that we are likely to see a radically altered view of justice in this country. Or to be more precise, we're likely to experience a set of regressive policies that harken back to the law and order regime of a Nixon administration. And those were the sorts of policies that led to the retributive path of crime control and racialized policing strategies from which we have yet to recover. So, as you likely know, the vast majority of criminal prosecutions take place at the state level, not the federal level, right? So about 211,000 people are locked up in federal prisons compared with 1.3 million in state prisons. But federal prosecutions could increase, so that could be one thing that we see as a change. But more troubling still, the federal government has the power of the purse and the pulpit, and it can encourage and advance retributive policies that will affect the state. So I'm going to talk a little bit about that as well. And so what I'm going to try to do in my 10 minutes is talk about the tone, the picks, and the effects of a Trump presidency on the experience of justice. And my comments will be less about constitutional issues and more about policy implications. And I think I should state up front that I'm not going to say much about immigration. I'm going to leave that to Adam, who's going to spend his time talking about that. So first, let me talk about the tone. Trump ran on a law and order platform because he likes to proclaim he believes that crime is out of control. So his priorities, or at least as he articulated them, and his nominee for Attorney General has articulated them, are to crack down on drugs and violent crime. And given those priorities, Trump has advocated a return to more aggressive anti-crime tactics. So let's start with some of those, some of the policing tactics that he is advocating. He's recommended the widespread use of stop and frisk by law enforcement, and will likely see incentives from the federal government to states in the form of federal aid to states to encourage the implementation of the kinds of policies that he would like to see spread. For example, the Office of Justice Programs has about $2 billion that it uses to fund programs in the states, and that money tends to flow towards policies that the administration is interested in spreading. But back to stop and frisk for a moment. As many of you know, the stop and frisk policies that were used by the New York Police Department and applauded by Trump were ultimately found to be unconstitutional in their application by Judge Scheindlin in Floyd versus New York. She concluded that the stops that were taking place were not based on reasonable suspicion and were not being conducted in a race-neutral way. What was happening was that blacks and Latinos were being stopped more than anyone else, and we were getting what could only be described as a ridiculously low success rate. 4.4 million people were stopped, 52% of those were followed by a frisk, 1.5% of those produced a weapon, so that meant that 98.5% of the 2.5 million frisks discovered no weapon whatsoever. So despite Trump's full-throated claims to the contrary, this was not a program that worked well, and he threatened that, or he at least suggests that reducing the use of stop and frisk would lead to an increase in crime, and at least New York's experience has been that the crime rate has actually declined since it stopped using stop and frisk. Which brings us to police oversight. Trump is calling for less regulation of police, and as you may know, the Obama Justice Department made great use of its power to investigate law enforcement agencies engaged in a pattern or practice of violating civil rights. The DOJ actually initiated 23 investigations and entered into 11 consent decrees, mandating reform in Chicago, Baltimore, Cleveland, and other cities. Attorney General, or at least his nominee, Attorney General Sessions, has condemned such interventions as an abuse of federal authority. What we're seeing is that Sessions and Trump are actually looking at some of the violence that police are engaging in against citizens as the behavior of quote-unquote rogue officers rather than the byproduct of a culture that too often sees itself as an occupying force in communities of color. So in addition to sort of being tone deaf to the incidents of police violence, we may see some reversal of some of the progress that's been made in the Obama administration, really maintaining strict oversight of police activities. What we've also seen in terms of the tone is that Trump's rhetoric has played to racial divisions by playing to a tried and true device that certainly propelled much of the criminal justice policymaking in the 80s and 90s. And that is, you look to stoke the fear of crime by suggesting that U.S. cities, particularly inner city neighborhoods, are drowning in crime. Trump uses inflammatory language, calling communities of color crime infested, as a way of setting the stage for draconian policies to eradicate the infestation. And that kind of language will actually lead to, I suspect, some really dangerous events because it's a dangerous and divisive message that enables us to use fear to drive policy choices. But we've also seen him use that kind of language to push an agenda that is really free of facts. Because facts are not his weapon of choice, explosive language is. And so his fact-free rants often invite drastic responses and make draconian tactics seem normal. So it perhaps should not come as a surprise that the National Fraternal Order of Police recently issued a wish list, easy for me to say, a wish list for the first 100 days of the Trump presidency that calls for Trump to reverse the Bush-era ban on racial profiling and to reinstate it to enable federal law enforcement to use it. He's set a tone, and people are beginning to pick up on that tone. If we look at his picks quickly, I think I have very little time. If you look at his picks quickly, he has chosen Jeff Sessions as the Attorney General, and it's perhaps his clearest message about his views on criminal justice. Sessions positions himself to the right of even his fellow Republicans on issues of crime, or as Time magazine suggests, he's firmly planted on the fringe. And what we see is that Sessions has opposed efforts to reduce unnecessarily long federal prison sentences for nonviolent crimes, despite a bipartisan effort to actually push that legislation. He actually made it a personal crusade to block that sentencing reform bill. He is very focused on drugs, really believes that we need to have essentially a war on drugs, and is concerned about the fact that we have moved away from those kinds of punitive policies. He adheres to them. When he was in Alabama, and Alabama became the first state to bring back the use of chain gangs in 1995, which was obviously a horrific remnant of Jim Crow. He, as Attorney General, defended it as perfectly proper. And the worry is that there's nothing in his public life since then that actually has convinced most of us that he is a different man than he was back then. And in 1986, he was, at the time, being considered to become a federal district court judge, and he was deemed too racially insensitive to be a federal district court judge, and yet he is the nominee for Attorney General. I think if we look at the effects finally, and I'll rush this and be willing to open this up to questions, but I think that we're going to see a number of things happen. We thought that there might be an end to the death penalty. The Supreme Court seemed to be hinting at that. But Trump supports a death penalty, Sessions supports it, and Trump will not likely nominate people to the court who will support his retributive policy. So the death penalty will likely continue. We may see a change in the composition of the federal judiciary. Sessions has expressed concern about appointing public defenders as federal judges because he worries about their agenda, and Trump seems to be in accord with that. We're likely to see an increase in people of color in prisons. Currently, no other country in the world imprisons so many of its racial or ethnic minorities. We imprison a larger percentage of our black population than South Africa did at the height of apartheid. That's likely to increase. So, not wanting to end on a low note, let me say that the agenda for activists, I think, is pretty clear. The fight has to be in the courtrooms, it has to be in the state legislatures, and in the media, because I actually think the center of gravity for reform will take place locally rather than federally.
Hi, I'm Adam Cox. I'm Adam Cox. I teach immigration and constitutional law here, and I'm going to talk a little bit about the constitutional issues that might emerge from Trump's immigration policies. So the first thing I guess I'd like to note is that the idea that presidential immigration policies might raise serious constitutional issues is obviously not new. President Obama's signature immigration initiatives prompted constitutional litigation brought by a couple dozen states that wound its way all the way to the Supreme Court, and ultimately his signature initiative was enjoined by the court system. So the intersection between immigration policy and constitutional law is very real right now, but the way in which the President-elect Trump's proposed policies are likely to raise constitutional questions is quite different than the way in which President Obama's were likely. And in particular, President Obama's policies regarding deportation were the ones that raised constitutional litigation that made its way to the court, whereas it's more likely to be the admissions policies, the entrance policies of the Trump administration that raise those constitutional questions. So let me explain a little bit why that is. So under the Obama administration in 2012, President Obama announced a policy initiative to protect roughly 1 million undocumented immigrants who'd come to the country when they were children. And then in 2014, expanded on that policy, announcing a new initiative that would have protected roughly 4 million other immigrants living in the country without legal authorization from deportation. Now, those policies, in particular the second one, which protected the parents of US citizen children and green card holders, prompted constitutional litigation challenging the president's authority to decide not to enforce immigration laws against some formerly deportable non-citizens. And the pool of formerly deportable non-citizens is obviously very, very large. So the most striking fact about American immigration policy today is that of the roughly 22 million non-citizens who live in the United States, half are formerly deportable. So obviously in that world, what matters most for immigration policy is not the rules that Congress makes so much as the choices that presidents and their administrations make about whom from among that very large pool of deportable people to pick and choose for purposes of deportation. Now, the choices that the Obama administration made were challenged in court in part on the ground that the president had effectively conferred a benefit on unauthorized immigrants by promising that they would not be deported. The Trump administration obviously is likely to rescind those policies, and the efforts that have been announced by President-elect Trump go in the opposite direction, right? They are policies that will likely increase enforcement levels overall, and also expand the group of potentially deportable immigrants who are subject to the enforcement machinery of the immigration bureaucracy. Because 11 million immigrants are living in the country without legal authorization, the president's decision to change those choices, right, even though it's a fundamental policy change, is very unlikely to raise significant constitutional questions because from within that large pool, the president just has significant power to pick those priorities. So the announcements by President-elect Trump to target in an even increased fashion the deportation of a group of immigrants labeled by the president-elect as criminal aliens, that might be a very significant policy change, but one that's unlikely to raise constitutional questions. And so instead, I think what's likely to happen is that the aggressive policy agenda on the admissions side of immigration policy is the one that's most likely to raise constitutional issues, and in maybe two different ways. So one set of policies that have been suggested, at least were suggested during the campaign by the president-elect and various advisors and supporters, are policies that seek to depress levels of lawful immigration to the United States, on the theory that our current immigration policies are simply too generous and don't work or serve the interests of the American people. Now, because so much of immigration policy is made by the administrative state and not by Congress itself, decisions to try to depress the level of lawful immigration will require that the Immigration Service, the Department of Homeland Security, and others make administrative changes to the way that visas are processed, applications are evaluated, and those decisions might themselves raise the same kind of constitutional challenge that Republican governors leveled against President Obama's deportation relief initiatives. And that is, there might be challenges that those policy changes cannot be made without more significant administrative process than the president-elect is likely to want to use to make those policy changes, right? So we're likely to see basically like the opposite political valence on the same kind of constitutional litigation that tries to force the administration to use more cumbersome procedures to change policy and therefore delay the policy change that the administration can accomplish. Okay, the second area of admissions policy that I guess has been more widely discussed, that's likely to raise constitutional issues, are proposals by President-elect Trump and candidate Trump to ban certain kinds of immigrants from coming to the United States. Now, obviously, this originated, I guess, a little more than a year ago in November of 2015 when then candidate Donald Trump proposed banning all Muslim immigrants from the country. That proposal has evolved like a number of times over the last year. I think Ryan and Adam both kind of mentioned it as there's a possible registry component in it today. But it remains a question whether the president has the authority to decide that some particular group of immigrants, whether identified on the basis of race or religion or ideology, or perhaps on the basis of other things like whether they come from countries that the administration believes have connections to terrorism, whether those kinds of immigrants can be, at the wish of the president, excluded from the country. Now, there's obviously a statutory question underneath that, whether Congress has given the president that power, but there's also a constitutional question. And the constitutional question is live in part because an odd aspect of immigration law is that many, many foundational questions about how the Constitution applies to immigration policy have just never been answered by the courts. And the foundational cases that gave us immigration policy today, cases that arose in the late 19th century when Congress first enacted restrictive immigration laws that in an openly racial fashion prohibited the entry of Chinese immigrants to the United States, those policies were sustained by a Supreme Court and gave rise to something known as the plenary power doctrine over immigration. Now, what that doctrine is and what it stands for has been like long debated and never resolved by our federal courts or certainly the Supreme Court. And that's what creates the possibility that policies that in ordinary domestic contexts would be considered obviously unconstitutional, like a policy that discriminates openly on the basis of race, creates the possibility that a court would sustain such a policy when the decision is whether or not to admit an immigrant on the basis of race or religion or ideology. Now, I think the fact that the Supreme Court in particular has been reluctant ever to formally resolve the question whether the Constitution applies in admissions context for immigrants in the same way that it applies in ordinary domestic contexts makes me think that it's going to continue to likely to be try to avoid that issue. And its avoidance might be facilitated by the administration itself. So while I guess I doubt that the current Supreme Court would actually sustain an immigration policy that openly excluded immigrants on the basis of race or religion, what we're more likely to see, of course, and what the more recent policy proposals reflect, are policies that say use proxies, like picking a list of countries in the way that the Bush administration did for either exclusion or special registration, where it happens to be the case that the list of countries chosen is highly correlated with nations that have significant Muslim populations or significant Arab populations or the like. And so policies that are correlated strongly with race or religion, those I think might be sustained by courts, but the reason that they might be sustained by courts actually doesn't have a whole lot to do with the way in which immigration constitutionalism is exceptional, and has a lot more to do with what Kim mentioned, which is the way in which ordinary domestic constitutional law actually does very little to regulate policies that are neutral on their face, but that are correlated with things like race and religion. The tests that litigants must overcome to demonstrate that those policies constitute unconstitutional discrimination are extremely demanding, and as a result, it's very difficult for profiling litigation in any context to succeed. So there's much more I could say. Sanctuary city policy is another area where I think there will be a lot of constitutional struggle between state and local governments and the federal government over immigration policy. But maybe I'll turn it over to Rick, because he can probably talk about that when he talks about localism.
Hi, I'm Rick Hills. I teach con law. I teach that leg reg course and a lot of state and local public law that's irrelevant to this panel. I was asked to talk about decentralization and localism and how Trump might affect that. And here's just 3 thoughts very quickly. I think there's 3 kinds of probable or plausible, either re-centralization or decentralization. To be precise, 2 kinds of re-centralization, 1 kind of decentralization that's probable or at least plausible under a Trump administration. So let's take the first kind of re-centralization. It's renewal of very conventional agency preemption that industry has been seeking for a long time and got a lot of under the second Bush administration. So for instance, California has a waiver to impose extra fuel efficiency on automobiles. They got it in the Obama administration under the Clean Air Act. I think the Trump administration will make a move to repeal that waiver. They'll have to go through notice and comment rulemaking, but they'll try to do that. Various states have consumer finance laws or blue sky laws. New York State has a famous law called the Martin Act that's used to go after lenders, banks, other businesses for fraud or for deceptive practices. There's a huge move in the second Bush administration to preempt these by the Office of the Comptroller of Currency. It was largely successful. After 2011, the Obama administration started to pull back on preemption. I suspect that the Trump administration shall try to reimpose that kind of preemption. A lot of tort liability has been imposed by states on things like pharmaceutical, entities like pharmaceutical companies for defective design or production of, generic drugs. There's been a lot of preemption action there. The Obama administration tried to limit that preemption. The Trump administration will certainly try to reimpose it. The thing I emphasize about this kind of re-centralization, it's very conventional. It's been the stuff of the Supreme Court's docket for the last at least 20 years. And when a Democratic administration's in power, the preemption tends to go down, and when a Republican administration in power, it goes up. Maybe that's comforting. Same old stuff. One difference I should add is that there has been certain kinds of statutory roadblocks or speed bumps to preemption. So the Dodd-Frank Act has a preemption clause that actually resists a lot of the kinds of preemption of state consumer finance laws that I think the Trump administration will likely seek. I know that Paul Atkins, who's a Trump advisor, was on the short list for chair of the SEC, wants to get rid of the Martin Act in the worst way. Might be difficult because Dodd-Frank says that any effort to preempt state consumer finance laws is subject to only Skidmore, not Chevron deference. It's one of the few cases where a statute actually cites a Supreme Court case in a preemption clause. Okay, a second kind of re-centralization will be enforcement of existing statutes against various subnational deregulatory efforts. So the first kind of case is where the states are trying to regulate a lot, and the Trump administration says, hold on, we want you to deregulate. Let those auto manufacturers alone. The second kind of centralization is where the states and locals want to deregulate, and the federal government says, hold on, we want you to regulate more. And the two obvious examples are medical marijuana and sanctuary cities. So Jeff Sessions hates marijuana. And he has said that he thinks that as a Schedule I substance under the Controlled Substances Act, it should be regulated. And so there's an outside chance that he might be so foolish as to try to go after Colorado drug dispensaries, marijuana dispensaries. I think that's an outside chance because the political fallout from that, having just come from Colorado, will be enormous. I mean, the idea that you're going to tell these harried soccer moms who are piling into, Manitou Springs, to get their, mother's little helper for the next trip. I just don't see that happening. The more serious effort will be his proclaimed effort to go after so-called sanctuary cities. Now, these are cities that have a law enforcement policy of not collecting or distributing data, immigrant data, about the immigrant status of people they detain or question. And you might ask, what tools does the federal government have in its toolkit to go after these cities to re-centralize, to re-regulate? There's two tools that the Trump administration could use. One is an existing statutory provision that actually has been on the books since, I think, 96. Hasn't been on the books since 96? Which says that no city can interfere with an individual officer's desire to cooperate with federal immigration authorities. So if there was an individual NYPD cop who was itching to help out ICE, locate people who are unlawfully present in the country, in theory, they could do so. Now, except for an opinion by Ralph Winter, I think in 2000, there's almost no discussion in the courts about what this means. If all it means is that individual cops can moonlight for the feds, it's not a real help to the federal government. I presume they could already work for the feds if they wanted to. If what it means is that the individual officers get to use proprietary data that they only have in their capacity as employees of the city, well, that raises really interesting constitutional questions. My own sense is there's a powerful argument that that's commandeering the city government. The officer has a badge, a gun, and a computer. But that's city stuff. And the fact that the officer wants to use it on behalf of the feds really doesn't mean that the feds are not, in fact, taking over city property. As you know, they can't do that from constitutional law. There's state autonomy doctrine that forbids that. The other tool that they could use against sanctuary cities is that they could try to pull various law enforcement grants, like federal OJP money. Cities do get a significant amount of law enforcement money, but it's not that much. It's not like huge ticket money. So in order for this cudgel to be effective against a city that has very large electoral incentives not to turn over immigration or collect immigration information, I think they'd have to go after other grants. They'd have to go for grants that are only tenuously related to law enforcement. Now, as you know from National Federation of Independent Businesses versus Sebelius, our own Chief Justice Roberts has written an opinion that says you can't go after unrelated money if it's a very large sum of money. And if it's a very large sum of money that looks like it's being used to coerce subnational governments into cooperating with the feds. And so, ironically, a precedent that liberals hate will turn out to be the last best hope of sanctuary cities. Because if Trump tries to go after, say, city Medicaid money, New York City actually gets Medicaid money, well, that would raise, I think, serious constitutional questions of state autonomy. So those are the two kinds of efforts where the Trump administration might try to suppress cities either by requiring them or forbidding them from regulating. I'm just going to close by talking about what I think is actually the most salient effect of the Trump administration on localism. I actually think it's likely to be a very decentralizing administration, simply because it's politically easier to decentralize. What do I mean by that? Well, the Obama administration did impose various civil rights mandates on cities and states. Let me give you some examples. The Dear Colleague letter from the Office of Civil Rights in the Department of Education enforcing Title IX sexual assault standards against both public and private universities. Betsy DeVos at her hearing talked a little bit about that policy. It's very likely to go by the wayside in a Trump administration. Since it was just a Dear Colleague letter, a stroke of a pen will take care of that policy. Title VI oversight of state courts or public schools. The Obama administration has sent out letters to state courts saying you better have translators, even in civil suits, even for plaintiffs, regardless of the wealth of the litigant. That caused a lot of anger from a lot of state judges. That's likely to go by the wayside. Again, it's just a letter, stroke of a pen gets rid of it. Affirmatively furthering fair housing. The Obama administration went after Westchester County, saying you got to desegregate your suburbs. That's just a lawsuit. They just closed the deal a couple weeks ago in a consent decree. I doubt there will be any more AFFH lawsuits to desegregate suburbs. The Prison Rape Elimination Act gives the Department of Justice oversight over state incarceration practices to reduce prison rape. Don't think that's going to be going on anymore. And then lastly, DOJ oversight of police behavior, for instance, in Chicago. I think that that's probably going to go down. Now, all of that are instances where the federal government actually decentralizes. That is to say, they just get out of the way and let state and local governments do what they want. Like it or hate it, it is an opportunity for you guys at the local level to do what you want. And the example I would give is New York City. New York City's crime rate has plummeted, and their police practices have improved. And part of that is that a lot of New Yorkers have done a lot about New York City. It's interesting that Chicago police are rougher, and yet they have a higher murder rate. New York City cops are under the oversight of a lot of people, including our own Peter Zimroth, who's sitting right there, the court-appointed mediator by Judge Shendlin on the stop and frisk case. And he's written excellent reports giving recommendations to NYPD. Well, he can continue to write reports. The Trump administration won't stop that. And they won't stop anybody else in New York City from improving our practices. So keep in mind that decentralization is both a risk, but it is an opportunity, and it's coming your way soon as a result of a new administration.